friends, welcome back to the series of lecture. This is the 59th lecture of this series of Indian Evidence Sect, and this is the last lecture of this upon this subject. Let's start with the topic Estopple, section 115. Please take out section 115. Estopple. When one person has, by his declaration, act or omission, when one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. So, when one person, suppose one person is A, when one person has by his declaration means what? Statement or act, doing some act, positive act, or some omission. Some person A by declaration, act or omission, then intentionally caused. intentionally caused, ये बहुत इम्पोर्टेंट है कि आपने अपोजिट पार्टी को अपनी बात पर विश्वास इंटेंशन के साथ करवाया. इंटेंशनली काउज्ड से बी, इंटेंशनली काउज्ड बी, caused or permitted another person to believe. Now another person is say B to believe what? To believe the truthfulness of whatever you are said, communicate. So to believe the truthfulness of some fact. To believe the truthfulness of some fact. इसकी language पढ़ोगे. When one person has by his declaration, act or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief. मतलब आपका इंटेंशन सिर्फ उसको विश्वास करवाने का नहीं था, आपका इंटेंशन था कि he must act upon your communication. Neither he nor his representative shall be allowed in any suit or proceeding. अब मान लो कल को A और B के बीच सूट हो जाए तो can A declares that no what I say is actually false. So did he allowed to retract from the correctness of his statement? The answer is no. That is what about the doctrine of Estopple. Provided, that is not very explicit, but provided that the other person has believed upon the fact and he had actually acted upon that. अब देखो ये बहुत कॉमन सेंस का टॉपिक है. Estoppel is based upon the public policy and the principles of equity and justice. Public policy and the private policy between the two parties. Principles of justice and equity. Suppose I make a communication. I tell you that mobile phone is mine. that mobile phone is mine and I want to sell it to you. If anyone give me 30,000 rupees, I will sell this mobile phone to you. तो आप लोगों को मैंने वैसे ही बोला कि ये मोबाइल फ़ोन मेरा है, मैं इसको बेचना चाहता हूँ, मुझे पैसों की ज़रूरत है और जो कोई आप लोगों में से मुझे 30,000 रुपीज़ दे देगा मैं उसको ये मोबाइल दे दूँगा. अब ऑन माई फेथ means you wanted, any one of you wanted the mobile phone. You went to arrange the money. You took loan on interest from someone. You took money. You took a loan from someone on interest. And now when you come to me to take my mobile phone, I will say that no, I was just joking. I say that this mobile phone is not mine. Will I be allowed to retract from this? When this I said, that was not a joke. Circumstances has to be seen. If when I said something which I actually intended that you believe upon it and you act upon it, I was quite serious when I said all that, and the circumstances were such where you believe and I intended to make you believe that this mobile phone is mine and I want to sell it. And then also my intention was you take money from somewhere to buy this mobile. You on my faith upon my communication. You have believed my communication on the fact that I want to sell this mobile phone and this is mine. You believed that. You believed on it, and on that faith, as per my intention, you have altered your position by taking that loan on interest from someone. And therefore, I now cannot be allowed to retract from the truthfulness of whatever I had said. अब अगर ये मोबाइल फ़ोन किसी और का होगा तो आप खरीद तो नहीं सकोगे एक्चुअली मुझसे, बट यू कैन ऑलवेज claim the compensation from me. So read it again. When one person has by his declaration, act or omission intentionally caused or permitted another person to believe, या तो आपने एक्चुअली उस पर विश्वास करवाया या फिर उसको परमिट किया विश्वास करने के लिए। जैसे उसने आपसे पूछा कि ये मोबाइल फ़ोन आपका है, आपने बोल दिया हाँ। मीन्स व्हाट? मीन्स यू परमिटेड हिम टू बिलीव दैट दिस मोबाइल फ़ोन इज योर्स। या फिर आपने खुद आगे बढ़कर कहा कि दिस इज माई मोबाइल फोन। सो you make him cause to believe that this is your mobile phone. So when one person has by his declaration, act or omission. So it can be by gestures. It can be even by gestures, by moving your head, anything that will also amount to the communication. So there has to be a communication. When one person has by his declaration, act or omission intentionally. That is very important. That is very important. I had the intention to make you believe. Intentionally caused or permitted another person to believe a thing to be true. To believe a thing to be true and to act upon such belief. I had the intention to make you believe. And I also had the intention to लिखा है ना कि and to act upon means I also had the intention to make you act upon my communication, my representation, my declaration. और इसी में implicit है that the other party has actually acted and he has altered his position. और अगर उसने act नहीं किया, alter position नहीं किया, तो तब तो estoppel नहीं लगेगा. So I had the intention to make you act on that belief, and you actually acted on that belief, and you have altered your position. Neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. तो आप अपनी बात से मना नहीं कर सकते, मुकर नहीं सकते. You see that it is based upon the doctrine of admission. It is based upon the doctrine of admission. Or you can also say that it is based upon the legitimate expectation. Doctrine of admission and legitimate expectation. Doctrine of legitimate expectation means what? मैंने अगर कुछ रिप्रेजेंट किया है, मैंने कुछ कहा है, मैंने आपको विश्वास करवाया है, इंटेंशनल मैंने आपको विश्वास करवाया है, means I admitted that fact to be true, and once I have admitted that fact to be true and you have altered your position on that faith, so now I cannot retract from that admission. Now I cannot retract from that admission. And similarly, when I have made admission and I have told you that this is true and you have do something, and now when you believe me upon my representation, so now when you believe me by representation and when I make you believe, when I intended to make you believe, then it is your legitimate expectation that what I have said is correct and I should perform my obligation. And if I do not, then your legitimate expectation is violated. Write down. Estoppel is based upon the doctrine of admission and legitimate expectation between the two parties. Estoppel is based upon the doctrine of admission and legitimate expectation between the two parties. It is a matter of public policy as based upon the principle of equity and justice. When a person intentionally makes another to believe in his representation, and he also intended to make other person to act upon that belief, then if the other person has actually acted and has altered his position on that faith, the has altered his position on that faith, the party who make the representation cannot now be allowed to retract from his original statement. Retract from his original statement. From the original statement, full stop. Even if the representation was false, the party will be bound by the representation. Even if the representation was false, the party will be bound by the representation. कौन सा party? जिसने representation किया था, that party. अब अपना promise fulfill ना भी कर पाए, लेकिन compensation देना पड़ जाएगा उसको. So he is bound by that representation. अब मैं promissory estoppel पर नहीं जा रहा, वो हम contract में देखेंगे. We are not talking in detail about the promissory estoppel. Generally, I am talking about the estoppel. The promissory estoppel क्या है? Me and you are in a contract, and I promise to do something for you, and you promise something to do for me, and on my faith you agreed, and then later on I retract from my statements, my representation. Then I am bound by promissory estoppel to perform the contract. अब इसमें मैक्सिम लिख लो आप. नेक्स्ट पैराग्राफ. elegans contraria non est audiendus. Elegans contraria non est audiendus. अब इसकी मीनिंग लिख लो. A person alleging contrary facts या contradictory facts shall not be heard. A person alleging contradictory facts shall not be heard. Means the court will not support the person who is alleging the contradictory facts. कभी कुछ बोल रहा है, कभी कुछ बोल रहा है, तो वैसे व्यक्ति को लॉ सपोर्ट नहीं करता. और इसी में एक और लिख लो. A person cannot be allowed to blow hot and cold at the same time. A person cannot be allowed to blow hot and cold at the same time. मतलब ऐसा व्यक्ति जो कभी कुछ बोल रहा है, तो ऐसे व्यक्ति को लॉ सपोर्ट नहीं करेगा. Hot and cold means at times he says something and now later on he says no, it was false. फिर एक और लिख लो इसमें. A person cannot be allowed to approbate and reprobate at the same time. At same time. A person cannot be allowed to approbate and reprobate at the same time. इसका मीनिंग भी वही है. You are saying one fact right now and later on denying that fact. Reprobate मतलब वापस लेना. Approbate मतलब assert करना. Assert fact right now and later on you deny that fact. So that will not be allowed. एक और sentence लग लो. Section 115 is the rule of exclusion. Rule of exclusion तो आपको पता होना चाहिए. Exclusion means what? कभी भी कोई लॉ किसी भी चीज़ को एडमिट होने से मना करता है, दैट इज एक्सक्लूजन. और कोई भी लॉ किसी चीज़ को एडमिट करवाता है, दैट इज इंक्लूजन. जैसे सेक्शन 91. सेक्शन 91 इज एक्सक्लूजन बिकॉज इट डिसअलाउज, एंड सेक्शन 21 इज इंक्लूजन, सेल्फ हार्मिंग स्टेटमेंट. तो ये वर्ड्स एक्सक्लूजन, इंक्लूजन किसी भी सेक्शन पे लगेगा. So any fact which is allowed by any section to be included will be called a principle of inclusion, and every fact which declared just 25-26 shall not be proved. Confession made to a police officer shall not be proved. So that is a principle of exclusion. So this is also a principle of exclusion because the party who has asserted the facts, he will not be allowed to retract from that. So that is the principle of exclusion. Okay. अब इसके बाद कुछ factual points है that you will write. तो इसको अगर points में लिखना चाहो तो points में लिख लो. First point, Estoppel applies on fact and not upon law or statute. मान लो A और B हैं, उन्होंने आपस में contract कर लिया. A and B are in contract and they agreed, and one of them promised that the period of limitation of this contract, the contract they have made, the period of limitation of that contract for the filing of the suit will be 6 months only, or say the period of limitation for the filing of the suit will be 6 years. वैसे तो 3 साल होता है. अब A committed a breach. B files a suit against A after 5 years for committing a breach. Now A take the plea of limitation into the court, that the suit is barred by the limitation under the Limitation Act. Now B raised the point that there is a clause in the contract in which we are mutually agreed, and in which he has promised me that he will allow me to file the suit after 3 years also for the next 3 years, means 6 years after the contract. And he say no, law says that you cannot file after 3 years. Now can B bind A by the principle of Estopple, that on the promise of you I did not file the suit within time, and therefore I should be allowed to file the suit, and you cannot now retract from it. Answer is no. तो यहाँ पर अगर लॉ को वायलेट करते हो आप by any agreement or by any promise or a representation, you are mutually violating the law, then estoppel will not apply. तो इसमें लिख लो आप, equity follows the law, therefore any agreement or representation which violates the law cannot be used to bind the party by estoppel. उसके बाद नेक्स्ट एक और पॉइंट लिखिए आप, that is the principle of Estoppel is based upon the case, that is Pickard versus Sears. ये पीटी में पूछते हैं as an English case, Pickard versus Sears, PICKARD versus SEARS. लिखो इसमें, Estoppel does not apply upon fraud or unlawful transfer of property. Estoppel does not apply upon fraud or unlawful transfer of property. Unlawful transfer of property is also called just a tie. ये 116 में भी डिस्कस करेंगे. JUSTERTII. Estoppel does not apply upon fraud or unlawful transfer of property. Means what? Suppose you have committed a fraud upon me, and by that fraud you have taken some kind of promise from me. You have taken a promise from me. Now, when I deny to perform my obligation, you claim that you are bound by estoppel. So can you bind me by estoppel, whereas you yourself committed a fraud upon me? Answer is no. क्योंकि फ्रॉड के केस में इक्विटी कैसे करोगे आप? आपने खुद फ्रॉड किया मेरे ऊपर, और जब मुझे फ्रॉड का पता लगा मैंने मना कर दिया परफॉर्म करने के लिए, and you are seeking that you are bound by the estoppel because you promised. So you are seeking equity. You are seeking equity for yourself. You are seeking equity from me for yourself on the basis of the estoppel. फ्रॉड किसने किया? आपने किया. estoppel कौन लगा रहा? आप लगा रहे हो मेरे ऊपर. मीन्स इक्विटी आप अपने हिसाब से लगा रहे हो. तो क्या इक्विटी सपोर्ट्स फ्रॉड? आंसर इज नो. तो उसी तरीके से if you misrepresented something to me and I transferred my property to you, but later on I discovered that it was fraudulent. You have committed a fraud upon me. I want my property back. And you said that no, you have transferred. Therefore, you are bound by the principle of estoppel. So, will equity be allowed to a person who has committed a fraud? Answer is no. right? Equity does not support fraud. Equity does not support fraud, and therefore a person who himself had committed fraud cannot be allowed to take the advantage of estoppel for himself, right? अब लास्ट पॉइंट बच गया एक एस्टॉपल में, दैट इज टाइप्स ऑफ एस्टॉपल. इसको आपको पीटी में पूछ सकते हैं. देखो प्रॉमिसरी एस्टॉपल का जो बेसिक्स है वो तो यही है जो हम पढ़ रहे हैं, बट द ओनली थिंग इज दैट इट इज रिलेटेड टू कॉन्ट्रैक्ट. तो 115 पे टाइप्स ऑफ एस्टॉपल ऑन दीज, मोर ऑफ ए थ्योरेटिकल काइंड ऑफ क्वेश्चन मीन्स में आ सकता है, बट 116 पर अप्लाइड क्वेश्चन आ सकता है. So let's write down types of estoppel. First one is estoppel by conduct. Second is estoppel by record. And third is estoppel by deed. And fourth is estoppel by pies. P-A-I-I-S. Estoppel by conduct, estoppel by record, estoppel by deed, and estoppel by pies. So conduct method, there is nothing to explain. Conduct means what? When you say something, when you do something by which you make the other person believe in your fact. So that everyone knows. Suppose I speak something to you, I say something to you to make you believe. So by speaking, suppose I say that this is my thing, this mobile is mine, that is estoppel by conduct. Then that is a statement made by me, that is also estoppel by conduct. Then estoppel by nodding my head, making you believe on something, that is also estoppel by conduct. तो estoppel by conduct तो जनरल है, आपका कोई कंडक्ट, आपका कोई स्टेटमेंट, आपका कोई एक्ट, आपका कोई ओमिशन that amounts the person to believing upon your statement or conduct. So write down upon it. First one, whenever a person makes a statement, acts or omission in order to make the opposite party believe upon a fact, it will be a case of estoppel by conduct. अब next one is estoppel by record. It is also called estoppel by judgment. इसमें भी लिखिए. So right, whenever a suit is heard and decided between two parties, finally, whenever a suit is heard and decided between two parties, finally, the parties will be bound by the principle of estoppel, and they cannot file same suit again. तो इसी प्रिंसिपल पर रेस जुडिकाटा भी लगेगा, उसको भी लिख लो. On the same issue, res judicata also applies. On the same matter, res judicata will also apply. तो res judicata के लिए कहा जाता है, one of the basic principle of the res judicata is estoppel. अब me and you are into a suit, and the suit is finally heard and decided. All facts, evidences. Now once the suit is finally decided, so you are bound to present all evidence in the suit. Means it is expected that you have presented all the evidences, and the court had, on the basis of our evidences, decided the suit once and for all. Now if any one of us files the same suit again in the trial court, you will be bound by the principle of estoppel. Now you cannot re-agitate the same thing because of the faith on these representations. The suit has already decided. So on the same point, res judicata also applies. और कहा जाता है कि res judicata का एक essential basis है principle of estoppel by judgment or record. ये भी लिख लो आप. One essential basis of res judicata is the principle of estoppel by record. Next लिखिए आप estoppel by deed. So right, whenever any deed, for example gift deed or sale deed, whenever any deed, for example gift deed or sale deed, has been recorded and has been signed by a party, he cannot now deny the contents of the deed unless he proves fraud. क्योंकि फ्रॉड पर estoppel नहीं लगेगा, तो unless he proves fraud. अब जजमेंट में भी सेम चीज़ है, याद करो आप, सेक्शन 44. ये फ्रॉड और कोलिजन प्रूव कर लो तो जजमेंट का रेस जुडिकाटा नहीं लगेगा। तो कहीं पे आप अगर फ्रॉड प्रूव कर दो तो एस्टॉपल विल नॉट अप्लाई, so that you already know. Now you see what is meant by estoppel by deed. Deed means what? That document. Now suppose I make a gift deed in favor of you and I get it documented and I signed it, and later on now I retract that no, I take back the gift deed. So I cannot do that. Once I have signed it, and obviously as per the registration act, once it is registered, then the deed is final, and now it cannot be taken back unless I prove that there is a fraud committed by the opposite party. That is what is called the estoppel by deed. अब estoppel by pious भी लगभग उससे ही मिलता जुलता है। अब ये estoppel by pious में क्या होगा कि आपने कोई डॉक्यूमेंट साइन नहीं किया है। अब it can be an oral agreement, it can be a documentary agreement. Suppose I promise to give you my house. I promise to give you my any property. Now even if that is not registered, after having given the promise, after having promised to give that property, I have actually transferred the possession of that property to you. अगर ट्रांसफर नहीं किया है तो पायस नहीं लगेगा, estoppel by pious नहीं लगेगा. But if I transfer the property to you, then the estoppel by pious will apply. The difference is that in deed वाले में the document is written and signed. Pious वाले में it is not necessary that there is documentation, even if it is an oral agreement and the property is actually being transferred by you. Deed में property का transfer होना जरूरी नहीं है, जैसे ही आपने साइन कर दिया the estoppel will apply. तो आपने ट्रांसफ़र किया या नहीं किया, लेकिन पायस में you have signed the document or not, that is immaterial. Even if it is an oral agreement, the moment the property has been transferred to the other party, estoppel by pious will apply. तो इस पे लिख लीजिएगा estoppel by pious पे, write down. It is estoppel by agreement or contract. It is estoppel by agreement or contract. It is not essential that the agreement should have been actually recorded. Rather, even if it was an oral agreement, the estoppel by pious will apply, if the property was actually transferred. The estoppel by pious will apply if the property was actually transferred. So is that fine? अब एक दो पॉइंट्स और हैं estoppel पे, वो भी लिख लीजिए आप. Estoppel binds the party who has made the representation. Estoppel binds the party who has made the representation. Binds the party who had made the representation. Then next point, estoppel does not in itself create a cause of action or a title. Estoppel does not in itself create a cause of action or a title. It also does not extinguish the right of a party. It also does not extinguish the right of a party. अब एक और लास्ट पॉइंट लिखो आप. The rule of estoppel is considered to be both procedural and substantive law. The rule of estoppel is considered to be both procedural and substantive law. It is called procedural. It is called procedural by Stephen. It is called procedural by Stephen and substantive by Best. तो ये पीटी से रिलेटेड पॉइंट है, उत्तराखंड वगैरह में पूछ लेते हैं. So it is called procedural by Stephen and substantive by Best. Okay. Now take out section 116. So read it very carefully. इसके डायमेंशन समझना बहुत जरूरी है, implied क्वेश्चन आते हैं. Section 116 is called extended doctrine of estoppel. लिख लीजिए आप, extended doctrine of estoppel मतलब principle of estoppel extend करना 116. So now please read. No tenant of immovable property or person claiming through such tenant. No tenant of immovable property or person claiming through such tenant shall, during the continuance of the tenancy, be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. फिर से पढ़ो, अभी सेकंड पार्ट नहीं पढ़ते हैं, फर्स्ट पार्ट पढ़ते हैं. इन द सेकंड पार्ट ऑल्सो द सेम interpretation will apply as it is in first part. Now you see there is a landlord and tenant relationship. There is a landlord and tenant relationship. उसी तरीके से there is a licensor and licensee relationship. अब ये दो जो relationships हैं again they are based upon mutual trust and faith, and therefore the mutual trust and faith shall be respected. अब suppose today, बहुत ध्यान से सुनना इसको, suppose today I took a house on rent from my landlord. आज मैंने कोई किराए पर मकान लिया लैंडलॉर्ड से. तो जब लैंडलॉर्ड ने मुझे मकान दिया और मैंने रेंट एग्रीमेंट साइन किया, then what is the declaration on my part? That I have examined and I know and believe that he is the owner of this property, and therefore I am taking house on rent from him as of today. Today when I took the house on rent from the landlord, today when I took the house on rent from the landlord, my declaration is that I have examined, by whatever means I have examined, and I declare hereby that he is the owner of the property, and therefore I accepting the property from him as a tenant. Now after that the tenancy continues. After that the tenancy continues, suppose for 5 years. Up during that 5 years, can I turn back and say that my landlord did not have the title to the property on the day when I took the house on rent? The answer is no. So that is what they are saying here. अब मान लो टेनेंसी यहाँ पर शुरू हुआ, इस दिन लैंडलॉर्ड और टेनेंट का रिलेशनशिप स्टार्ट हुआ. अब टेनेंसी कंटिन्यूज till this period, till here tenancy continues. On this date the implied declaration by the tenant was got that the landlord has the rightful title to the property, and therefore I am taking the property on rent from you. Now after that as long as the tenancy continues, if on some day the tenant says that my landlord did not have a title to the property on this date, then that will not be allowed. क्योंकि जैसे ही उसने मकान किराए पे लिया था, तो उसका एक इम्प्लाइड डिक्लेरेशन है कि मैं मानता हूँ ये व्यक्ति इस मकान का मालिक है. The landlord is the owner of the house, and therefore now he cannot turn back and say that he was not the owner of the house when I took the house on rent. लेकिन इसमें ये कहीं पर भी नहीं लिखा है इस सेक्शन में. अब मान लो on this date the landlord sell this house to someone. Now after this date this landlord is not the owner of this property. अब this tenant can always deny that now my landlord is not the owner. Means by subsequent change of circumstances, if the landlord does not remain to be the owner, then will the tenant can deny that? Yes, the tenant can deny that after that. But the original day when the tenancy had started, regarding that date, as long as the tenancy continues, he cannot deny that my landlord was not the owner on that date. Unless he proves fraud, then the estoppel will not apply. So if he proves that the landlord fraudulently has shown me the false document, तब तो वो डिनाई कर सकता है क्योंकि फ्रॉड पर estoppel नहीं लगता है. लेकिन अगर फ्रॉड प्रूव नहीं कर पाता, then in that case किस डेट के लिए मना नहीं कर सकता? उस डेट के लिए जिस डेट पे टेनेंसी स्टार्ट हुआ था. लेकिन उसके बाद अगर लैंडलॉर्ड बाय द सब्सिक्वेंट चेंज ऑफ सर्कमस्टेंसेस he no more remains the owner of the property, so the tenant can deny that, but not for the first day. तो दोबारा पढ़िए इसको ध्यान से. No tenant of immovable property, no tenant of immovable property or person claiming through such tenant, हो सकता है tenant अगर मर गया हो उसका legal representative एक्सेट्रा, no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy, means for what period the prohibition, as long as the tenancy continues, shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had at the beginning of the tenancy, means on the first day when the tenancy started, had at the beginning of the tenancy a title to such immovable property. मतलब there is a landlord tenant relationship, which started here. The landlord tenant relationship started here. Now the tenancy continues for this period. Now all this period, as long as the tenancy continues, all this period जब तक ये लैंडलॉर्ड टेनेंसी रिलेशनशिप चल रहा है, टेनेंट कभी भी पलट कर ये नहीं कह सकता that on this date my landlord was not the owner of the property. So is that fine? Can he say so? Can he say so regarding any subsequent date? There is no bar. So if the landlord's title has changed due to subsequent change of circumstances, the title is changed, then he can deny that. But he cannot deny that on the first date that the landlord does not have the title. अब मान लो द टेनेंसी ओवर हियर, अब इधर टेनेंसी खत्म हो गई, अब क्या उसके बाद ही कैन डिनाई दैट माई लैंडलॉर्ड डज नॉट हैव द टाइटल ऑन द ओरिजिनल डेट, because they are clearly writing as long as the tenancy continues, during the continuance of the tenancy, means the bar upon the tenant applies only as long as the landlord tenant relationship continues. The moment the tenancy is over, after that the bar of 116 will not apply. Now what comes out is 2 points. One is that the purpose is basically to create the stability in the landlord and tenant relationship, and the second thing is what is prohibited, the denial of the title of the landlord as on the day when the tenancy started. उस डेट के लिए denial is prohibited, and as for how long it is prohibited only as long as the tenancy continues. Therefore, can the tenant deny the title on the first date? On the first date after the tenancy get over? Yes. And can the tenant during the continuancy of the tenancy deny the title of the landlord by subsequent change of circumstances? Yes. And can the tenant deny the title of the landlord on the first date during the continuancy of the tenancy if it is obtained by fraud? If the tenancy is obtained by fraud, when the landlord has committed the fraud? Answer is yes. You write down. Section 116 is based upon the principle of Estopple. Section 116 is based upon the principle of Estopple. The purpose is to bring about the stability in tenant and landlord or licensor and licensee relationship. The day when the tenant and the landlord or the licensor and licensee relationship started, the tenant or the licensee is deemed to have made an implied declaration that he considered the landlord to be having the title to the property, and therefore as long as the tenancy or license continues, he is prohibited from denying the title of the landlord or the licensor as on the day when the tenancy or license commenced, unless he proves fraud on the part of the landlord. Now next paragraph. The prohibition continues only as long as the tenancy continues. And therefore, after the tenancy has got over, the tenant can deny such title of the landlord. Such title matlab title on the first day. Title on the first day. The tenant can deny such title of the landlord. ठीक? Then next sentence. Change the paragraph. The title cannot be denied during the continuance of the tenancy. During the continuance of the tenancy between the landlord and the tenant. Between the landlord and the tenant. Even if the landlord had a defective title on the day of commencement of tenancy. On the day of commencement of the tenancy. So when I say tenancy, it will all license also. तो ये बहुत important है. Even though landlord had a defective title on the day of commencement of tenancy, provided that landlord had not committed any fraud. Provided that landlord had not committed any fraud. अब देखो मान लो इस दिन tenancy start हुआ. This is the day when the tenancy started. On that day, the landlord actually had the defective title. But maybe the landlord does not know about it. So he had not committed any fraud. अगर fraud है तो Estoppel ही लगेगा. Sorry, Estoppel नहीं लगेगा. अगर fraud है तो Estoppel नहीं लगेगा. Now then landlord has the defective title, but he did not know about the defect. He gave that house on the tenancy, and the tenant believes that the landlord has the title. अब उसके बाद somewhere here the tenant comes to know that the landlord does not have the title. Somewhere here he knows that it is defective and he is not having the title. Now can he turn back and say that my landlord does not have the title? Now even if it was defective, he cannot do so unless he is able to prove fraud. Is that fine? Even if it is defective, he cannot do so unless he proves so that the landlord has committed fraud. अब नेक्स्ट पैराग्राफ लिखो इसमें. ये सब एक केस से लिख रहे हैं हम, जिसका नेम अभी बाद में लिखेंगे. However, if there is a subsequent change of title, of the landlord during the continuance of the tenancy, then such subsequent title can be denied. फर्स्ट डेट का तो फिर भी डिनाई नहीं कर सकते आप. Then such subsequent title can be denied. फिर भी तब भी आप पहले दिन का डिनाई नहीं कर सकते. लेकिन अब बाद में ये टेनेंट वो लैंडलॉर्ड नहीं रहे ड्यू टू सब्सिक्वेंट चेंज इन सर्कमस्टेंसेस, तो अब आप कह सकते हो दैट नो ही इज नॉट माई लैंडलॉर्ड. अब एक और लास्ट पैराग्राफ लिखो. इट इज नॉट एसेंशियल दैट द प्रॉपर्टी वाज हैंडेड ओवर टू द टेनेंट. It is not essential that the property was handed over to the tenant personally by the landlord. Rather, even if the agent of the landlord had given the property, the prohibition of section 116 will apply between the landlord and tenant. Now that is quite logical. अब जैसे मैं विदेश में रहता हूँ, मैंने अपना मकान किसी एजेंट को दे रखा है और एजेंट ने आपको किराए पे दे दिया. सो इट इज एज इफ आई एम गिवन द हाउस टू यू बिकॉज एजेंट इज इन माई कंस्ट्रक्टिव पोजेशन. सॉरी, द हाउस इज इन माई कंस्ट्रक्टिव पोजेशन. अब मैंने प्रॉपर्टी आपको नहीं दी डायरेक्टली, मेरे एजेंट ने दिया. सो द सेम रूल विल अप्लाई बिटवीन मी एंड द टेनेंट बिकॉज द एजेंट इज एक्टिंग ऑन माई बिहाफ. अब ऑल दीज पॉइंट्स आर हेल्ड इन अ केस. राइट डाउन द नेम ऑफ द केस. Write down the name of the case. Bansraj Lalta Prasad versus Stanley Parker Jones. That is 2006 Supreme Court. So whatever I have dictated to broadly is taken from this case. The one last point remain to discuss is basically the point is, मान लो आज एक लैंडलॉर्ड है जिसके पास डिफेक्टिव टाइटल है, लेकिन बोनाफाइड उसको विश्वास है कि मेरा टाइटल सही है और उसने एक टेनेंट को मकान दे दिया. अब उसके बाद उस लैंडलॉर्ड ने वो मकान किसी ए को बेच दिया. अब there is subsequent change of the title of this landlord. Now since this landlord also have the defective title, because the original landlord has the defective title, the transfer landlord is also have the defective title, but neither of them knew it, so neither of them committing any fraud. तो अब जैसे ही नए मकान मालिक को मकान बेचोगे, the tenant will have to atone the tenancy with the new landlord. Now he is paying the rent to the new landlord. So the question was, can this tenant now deny the title of the new landlord? Now he could have denied if it was case of fraud, but there was no fraud. Now can he deny the title of the new landlord on the basis that my earlier landlord have the defective title? Answer is no, because he could not deny the title of the original landlord, and now since he has adorned the tenancy, the day he has adorned the tenancy means what? Adornment मतलब क्या? Acknowledgement. तो जब उसने acknowledgement of नया landlord कर दिया, उस दिन he has accepted that he has the title, तो उसका टाइटल आप डिनाई नहीं कर सकते इस बेसिस पर कि पहले लैंडलॉर्ड के पास टाइटल डिफेक्टिव था. So the answer to this is you cannot deny the title of this new landlord even if he had obtained a defective title, because the original landlord has the defective title, provided neither of them has committed fraud. Write down the name of the case. Tejbhan Madan versus second ADJ 1988 Supreme Court. 1988 Supreme Court. Tejbhan Madan versus second ADJ 1988 Supreme Court. It was held, write down, it was held that if the tenant gets into a tenancy agreement with the landlord who had a defective title, then also the tenant cannot deny the title of the landlord during the continuance of the tenancy, provided the landlord had not committed any fraud upon the tenant. That is, the landlord did not have the knowledge of the defect in the title. So suppose this is the day when you get into the tenancy with the landlord 1 and the tenant. Now this landlord had a defective title. Now this landlord has a defective title of which he is not aware. Now as long as this tenancy goes on, the tenant cannot deny the title of the landlord on the day when tenancy started. On the day when the tenancy started, even if the title was defective, the condition is what? That no fraud was committed by the landlord. अब मान लो he was not aware of that, किसी judgment में उसको title मिला था, he got a title in some judgment and the judgment was defective, but the landlord believed that bona fide that I am the owner. अब आगे लिखो next paragraph. If during the continuance of the tenancy the original landlord sells the property to some other person, then the tenant has to atone matlab acknowledge, the tenancy of the new landlord. Off mat karo, with karo. By atone the tenancy with the new landlord, has to atone the tenancy with the new landlord by making the payment of rent to him. Once the acknowledgement has been done, the tenancy starts with the new landlord, and now section 116 has to applicable with respect to the new landlord, and therefore as long as the tenancy with the new landlord continues, the tenant cannot deny the title of the new landlord as on the date when the atonement was done as on the date when the acknowledgement was done. अब यहाँ तक क्लियर है आपको? अब इस डेट पर लैंडलॉर्ड 1 sells the property to landlord 2 and therefore the acknowledgement is done on this date. The tenant pays the rent to the new landlord and from there the tenancy starts with the new landlord. Now, as long as this tenancy continues with the new landlord, the tenant cannot turn back and declare that the new landlord does not have the title on the day when the acknowledgement was done. क्यों? टेनेंसी तो उसी दिन शुरू हुआ, तो टेनेंट अब पलट कर ये नहीं कह सकता कि नए लैंडलॉर्ड का टाइटल उस दिन नहीं था जिस दिन मैंने एक्नॉलेजमेंट किया. 116 will apply. अब the issue here was that can this tenant now during this period deny the title of the old landlord? Answer is yes, क्योंकि पहले वाले लैंडलॉर्ड के साथ टेनेंसी खत्म हो गया उसका. आपने यही पढ़ा है, जिस दिन टेनेंसी खत्म हो जाए उसके बाद आप डिनाइल कर सकते हो. तो पहले वाले लैंडलॉर्ड के साथ टेनेंसी किस डेट पर खत्म हुआ? डेट ऑफ अटॉर्नमेंट. पहले वाले लैंडलॉर्ड के साथ टेनेंसी डेट ऑफ अटॉर्नमेंट पे खत्म हो गया एंड देयरफॉर ही इज फ्री टू डिनाई द टाइटल ऑफ द ओरिजिनल लैंडलॉर्ड. ठीक, ये समझ में आया? ही इज फ्री टू डिनाई. अब ध्यान दीजिएगा, द अटॉर्नमेंट वाज डन ऑन दिस डेट विद द ओरिजिनल लैंडलॉर्ड एंड द अटॉर्नमेंट वाज डन बाय द सेकंड लैंडलॉर्ड on this date. Acknowledgement is done on this date. So after that the tenancy with the original landlord was over or not? तो एक मकान मालिक चला गया तभी तो दूसरा आया है. अब इस डेट से ये नया लैंडलॉर्ड LL2, जब नया लैंडलॉर्ड उसका टेनेंसी उसके साथ चल रहा है तो उसका टाइटल ये डिनाई नहीं कर सकता. दैट इज फाइन. अब कैन ही टर्न बैक एंड डिनाई दैट द ओरिजिनल लैंडलॉर्ड डज नॉट हैव द टाइटल? Obviously the tenancy is no more. Suppose he says that my original landlord does not have the title, then the issue was on that basis. Can he says that my new landlord does not have the title because my old landlord does not have the title, so he could not transfer the perfect title and therefore my new landlord does not have the title on the day when the tenancy started with the new landlord. फिर से सुनो, पहले वाले लैंडलॉर्ड के साथ उसका टेनेंसी खत्म हो गया, नए वाले लैंडलॉर्ड के साथ एक्नॉलेजमेंट हो गया. अब ड्यूरिंग द कंटिन्यूएंसी ऑफ द टेनेंसी विद द नया लैंडलॉर्ड ही कैन नॉट डिनाई दैट द माय न्यू लैंडलॉर्ड डिड नॉट हैव द टाइटल ऑन द डे व्हेन द एक्नॉलेजमेंट वाज डन. दैट इज फाइन. अब कैन ही नॉट डिनाई द टाइटल ऑफ द ओरिजिनल लैंडलॉर्ड? कैन ही डिनाई द टाइटल ऑफ द ओरिजिनल लैंडलॉर्ड? क्या वो डिनाई कर सकता है ओरिजिनल लैंडलॉर्ड का टाइटल? द आंसर इज यस, बिकॉज दैट टेनेंसी इज ओवर. अब नाउ इफ यू डिनाई द टाइटल ऑफ द ओरिजिनल लैंडलॉर्ड, कैन ही डिनाई ऑन दैट बेसिस द टाइटल ऑफ द न्यू लैंडलॉर्ड, द टाइटल ऑफ हिज न्यू लैंडलॉर्ड ऑन द डे ऑफ एक्नॉलेजमेंट और अटॉर्नमेंट? क्योंकि ओरिजिनल लैंडलॉर्ड के पास टाइटल नहीं था, दैट ही कैन डिनाई. तो उस बेसिस पर में my new landlord does not have the title, तो उसके बेसिस पे my new landlord does not have the title, can he deny that? Answer is no. 166 will apply rigidly in this case. Even if he is capable of denying, even if he is now capable of denying the title of the original landlord, on that basis he cannot now deny the title of the new landlord as long as the tenancy with him continues. तो वहीं पर स्टॉपल लगता है, प्राइवेट स्टॉपल है, दोनों के बीच लगता है. Even though he is not having the perfect title, in TPA we studied the person cannot transfer a better title than he have. So even though he is not having a perfect title, but for tenant के लिए he is having a perfect title on the day when the tenancy was acknowledged. अब इसको लिख लीजिएगा. Right? After the tenancy with the original landlord got over, he can now deny the title of the original landlord on the day of the commencement of that tenancy. On the day of commencement of that मतलब original landlord, that tenancy. It is a known fact that the new landlord also had a defective title. It is a known fact that the new landlord also had a defective title. New landlord had also had a defective title as the original landlord, could not have transferred him a perfect title. However, still upon the tenant, Estoppel under section 116 will apply. Still upon the tenant, Estoppel under 116 will apply, and he cannot deny the title of new landlord as on the date of atonement or acknowledgement. As on the date of acknowledgement, मतलब जिस दिन एक्नॉलेजमेंट हुआ था उस दिन मकान मालिक का एक्चुअली में डिफेक्टिव टाइटल था, लेकिन उसने फ्रॉड नहीं किया था इसके साथ. He purchased the property believing that it is his property, the original landlord's property. So bona fide he purchased the property. So the rent continues. So the atonement ka day, you have a defective title, but he believed to be a proper title, and tenant also believe it to be proper title. So even if the title was defective, even if he now can deny the original landlord's title, but on that basis he cannot deny the title of the new landlord as long as the tenancy not get over. So that is the importance of section 116, because we all know that the title was defective. अब किसी के साथ अगर सूट हो जाए उसका, तो वो सूट में हार जाएगा लैंडलॉर्ड ओनर, क्योंकि टाइटल डिफेक्टिव है. लेकिन ये जो टेनेंट है उसके खिलाफ अगर सूट हो जाए तो टेनेंट उसका टाइटल कभी भी डिनाई नहीं कर सकता. So is that fine? So by that we get over this section. So by this topic we get over with the evidence. This is the last lecture. And now let's discuss some points of the previous topics. मान लो कोई चर्च में जाकर कन्फेशन करता है किसी फादर से, तो क्या एविडेंस एक्ट में कोई प्रोटेक्शन मिलता है कि वो फादर को कन्फेस कर रहा है कोई व्यक्ति, और फादर जाके एविडेंस दे दे कोर्ट में जाके? देयर इज नो प्रोटेक्शन अपॉन इट because it is not a privileged communication, even though religious prohibition is there but not a legal prohibition. तो फादर कोर्ट में जाकर बयान दे सकता है कि इसने ये कन्फेशन किया था. अब सिमिलरली अनदर क्वेश्चन, सपोज एन अपॉर्चुनिटी ऑफ क्रॉस एग्जामिनेशन इज नॉट गिवन to the opposite party, opportunity of cross examination is not given to the opposite party, then what will be the consequence? अगर अपॉर्चुनिटी नहीं दिया अपोजिट पार्टी क्रॉस एग्जामिनेशन का, then that particular fact is not said to have been proved. जिस फैक्ट को प्रूव करने के लिए विटनेस आया था, अगर उसका क्रॉस एग्जामिनेशन नहीं हुआ या अपोजिट पार्टी को क्रॉस एग्जामिनेशन का राइट नहीं दिया आपने, then that fact will not have deemed to have been proved. सिमिलरली एक न्यू पॉइंट बताता हूँ आपको. सपोज इन्वेस्टिगेशन चल रही है किसी ऑफेंस में, एक्यूज्ड है हस्बैंड, और वाइफ को पुलिस ऑफिसर इन्वेस्टिगेशन के लिए पकड़ के ले गई. अब वाइफ के साथ हस्बैंड ने प्रिविलेज कम्युनिकेशन की थी, उसको सारे फैक्ट्स पता है क्राइम के, व्हाट हिज हस्बैंड हैज डन. तो वाइफ उन सारे फैक्ट्स को पुलिस ऑफिसर्स को बताती है, तो क्या यहाँ पर प्रिविलेज कम्युनिकेशन लगेगा? अब ध्यान रखिएगा, प्रिविलेज्ड कम्युनिकेशन ऑलवेज अप्लाई इनटू द ट्रायल, इन्वेस्टिगेशन में नहीं लगेगा. तो बेशक उसके जो बयान है उसके ऊपर इन्वेस्टिगेशन कर रही है पुलिस, उससे उसके बेसिस पे फैक्ट्स और एविडेंसेस कलेक्ट कर रही है. इन्वेस्टिगेशन इज टोटली बेस्ड अपॉन द स्टेटमेंट्स गिवन बाय द वाइफ, देन ऑल्सो द प्रिविलेज्ड कम्युनिकेशन विल नॉट अप्लाई बिकॉज इट ओनली अप्लाई इन द ट्रायल. अब सपोज when lawyer comes to know about his client that he has done this crime, अब वो लॉयर किसी थर्ड पर्सन से कह देता है कि माई क्लाइंट हैज डन दैट क्राइम. अब क्या वो थर्ड पर्सन एविडेंस दे सकता है उसका? क्या वो थर्ड पर्सन उस स्टेटमेंट को क्लाइंट के खिलाफ यूज कर सकता है? कर सकता है. आंसर इज यस. लेकिन जब ये थर्ड पर्सन कोर्ट में बयान देगा दैट सो एंड सो पर्सन टोल्ड मी दैट हिज क्लाइंट हैज कमिटेड दैट क्राइम, and his statement will be hearsay. Suppose you tell me that your client has committed murder, then I go to the court to give the evidence that this client has committed the murder, his client, this person committed the murder, then obviously my testimony is hearsay because the lawyer told me and I did not see it happening. You have told me, and if you have told me, then obviously it is hearsay. Now ultimately you have to appear into the court. And who are you? लॉयर, और लॉयर जैसे ही अपीयर होगा तो वहाँ प्रिविलेज कम्युनिकेशन लग जाएगा, एंड देयरफॉर मेरा जो एविडेंस है उसका कोई बेनिफिट नहीं हुआ, इट कैन नॉट बी प्रूवन एविडेंस. One more point, the presumption to section 112 is applies to presumption of section 112 as to the paternity of child is applicable to Muslims or not. Now you see, section 112 is a secular provision and it applies upon all religion. It applies upon Hindu, Muslim, on every religion. Now next point, suppose एक approver है, suppose an approver is unable to recall a fact and he voluntarily gives narco test, and the statement made by him also includes self-incriminating statement, then these statement can be used against him or not. अब देखो, नार्को का कोई भी कंक्लूजन एविडेंस में यूज नहीं हो सकता. वॉलेंट्री अगर किया था तो वो डिस्कवरी स्टेटमेंट के फॉर्म में यूज हो सकता है, वो भी कब, जब आप खुद एक्यूज्ड होते तब. और यहाँ पे ही इज एन अप्रूवर, तो इन दैट केस ही इज जस्ट अ विटनेस. तो मान लो पहली बात, विटनेस का आप नार्को टेस्ट करवाओगे क्यों, और मान लो करवा भी लिया, करवा सकते हो, तो इसमें जो भी वो बयान देगा दैट इज ऑल इनएडमिसिबल, इवन इफ इट इज इनवॉलेंटरली, इवन इफ इट इज वॉलेंटरली, अगर वो वॉलेंटरली भी है तब भी इट इज ऑल इनएडमिसिबल एक्सेप्टिंग द डिस्कवरी स्टेटमेंट. द डिस्कवरी स्टेटमेंट कैन नॉट बी यूज्ड अगेंस्ट द एक्यूज्ड बिकॉज ही इज एन अप्रूवर. तो वो जो डिस्कवरी स्टेटमेंट उसने दिया वो दूसरे वाले एक्यूज के खिलाफ यूज नहीं हो सकता. लेकिन इफ ही हिमसेल्फ बिकम एन एक्यूज टुमारो, देन अगेंस्ट हिम दैट डिस्कवरी स्टेटमेंट कैन बी यूज्ड. अब सपोज इफ अप्रूवर गिव स्टेटमेंट अंडर नार्को एनालिसिस, would it be admissible under section 27? 27 में यूज तभी होगा जब अप्रूवर इज एन एक्यूज्ड. लेटर ऑन एक्यूज्ड अगर देता है वॉलेंटरली तो 27 में उसके खिलाफ इस्तेमाल हो सकता है. सेल्वी वर्सेस स्टेट ऑफ कर्नाटका, वी हैव रीड इट, स्टडीड इट. नेक्स्ट पॉइंट, सपोज देयर इज हस्बैंड वाइफ, दे आर लिविंग इन जुडिशियल सेपरेशन एंड दे कम्युनिकेट, स्टिल देयर कम्युनिकेशन इज प्रिविलेज्ड बिकॉज दे आर स्टिल अ हस्बैंड एंड वाइफ. लेकिन जब उनका डिवोर्स हो जाएगा देन देयर कम्युनिकेशन विल नॉट बी प्रिविलेज्ड. सो दैट्स इट फॉर दिस lecture, and by this lecture we get over with the Evidence Act. Thank you.